I'm Peter Cline, a disability insurance lawyer with McLeod Law, and I often get asked the question, what to do if my long-term disability benefits are either cut off or denied in the first instance. So you probably first received a phone call from your claims handler advising that the insurance company was denying your claim for long-term disability or LTD benefits. If you haven't already, you will soon receive a letter setting out the reasons for the denial. You may find these reasons to be very brief and possibly unhelpful. You will also most likely be invited to appeal that decision. The letter will say that you should provide any new additional information you might have in support of your claim, and you will probably be given 90 days to do so. So the first decision to make is whether you should in fact appeal. That will mostly depend on whether you or your doctors actually have any new additional information to provide to the insurance company. If you do, then an appeal might be a good idea. Many claims for LTD benefits are turned down in the first instance because the information provided in support is simply lacking. Additional helpful information may be just enough to tip the balance in your favor. If you think you will need more than 90 days to provide this information, then just let your claims handler know that. On the other hand, if you feel you have provided everything you can that will be helpful to the insurance company, or you were not even invited to appeal, or you were otherwise told that the decision was final, then you need to talk to a disability insurance lawyer, because your better choice at that point is to proceed with a legal claim. If you're thinking about appealing to the insurance company, you also need to be mindful of any time limitations you might face. And I don't mean the 90 days you are given to appeal. I mean the time within which you have to commence a legal action against the insurance company, failing which you will be barred from being able to pursue your disability claim. That's called a limitation period. It may or may not be referred to in the denial letter you receive from the insurance company. In Alberta, most of the time, you have 2 years within which to commence a legal action. In the case of disability insurance claims, that 2-year clock starts to run from the time the insurance company communicated to you that they were denying your claim. Now understand that even if you appeal the decision and the insurance company agrees to review your appeal, that 2-year clock continues to run. It doesn't stop. If you find yourself facing a denial of your claim for long-term disability insurance benefits, or simply have questions about your disability claim or that of a loved one, please feel free to contact me, Peter Cline at McLeod Law, and I'll be happy to provide you with a free, no obligation initial consultation. Thank you.